An interesting turn of events in the governor versus state saga. It has been a long-standing problem now, governors sitting on bills passed by the state assemblies and the states in question challenging this in court. Tamil Nadu, Kerala and Punjab have approached the Supreme Court to decide a time frame for which governors have to either return or grant assent to bills passed by legislatures, because Article 200 states provided that the governor may, as soon as possible after the presentation to him of the bill for assent, return the bill if it is not a money bill, together with a message requesting that the House or Houses will reconsider the bill. So two important observations have been made by the Supreme Court in its judgment in the State of Punjab versus Governor case. The first one is regarding the time frame for the governors to work on the bill. The phrase "as soon as possible" in Article 200 has been the point of contention. Since the article does not specify a time frame, the phrase "as soon as possible" was left for interpretation. But now, the Supreme Court in its judgment has warned that "as soon as possible" conveyed a constitutional imperative of expedition. The order read, "The expression 'as soon as possible' is significant. It conveys a constitutional imperative of expedition. Failure to take a call and keeping a bill duly passed for indeterminate periods is a course of action inconsistent with that expression. Constitutional language is not surplusage." Now on to the second aspect. What should the governor do with a bill passed by the state assembly after withholding it? According to Article 200, three courses of action are open to the governor: grant assent, withhold assent, or reserve the bill for President's consideration. Now, there was an ambiguity as to whether the governor is bound to return the bill to the assembly if they are declaring that assent is withheld. This situation arose recently in Tamil Nadu, where Governor R.N. Ravi declared that he was withholding assent over certain bills. The governor did not return those bills to the House. During the hearing of the writ petition filed by the state of Tamil Nadu against the Tamil Nadu governor's inaction on bills, the Supreme Court had pondered on whether the governor is bound to return a bill to the House after withholding assent, or whether the governor can simply say that he was withholding assent. Now, in its verdict in the case with regards to Punjab, the Supreme Court has held that if a governor decides to withhold assent to a bill, then he has to return the bill to the legislature for reconsideration. Here is what the Supreme Court order says. The substantive part of Article 200 empowers the governor to withhold assent to the bill. In such an event, the governor must mandatorily follow the course of action which is indicated in the first proviso of communicating to the state legislature as soon as possible a message warranting the reconsideration of the bill. The ultimate decision on whether or not to accept the advice of the governor as contained in the message belongs to the legislature alone. That the message of the governor does not bind the legislature is evident from the use of the expression "if the bill is passed again with or without amendments." Tamil Nadu has accused Governor Ravi of toying with the citizens' mandate by sitting on the bills by neither assenting nor returning them. Punjab complained that 7 of its bills were stuck with Governor Banwarilal Purohit since June, threatening to bring the administration to a grinding halt. Kerala, in its separate petition, said that 8 proposed laws passed by its legislative assembly were pending with Governor Arif Muhammad Khan. Not for months, but years. Also, the Supreme Court had to intervene in April for Telangana Governor Tamilisai Soundararajan to clear bills pending since September 2022. So, with so many states having a tiff with their respective governors, the Supreme Court's judgment does clarify one aspect of the problem, which is about the governor's actions regarding a bill. But there is still no specific time frame for governors to respond to the bills, and it remains to be seen whether this Supreme Court order addresses this aspect adequately.
Subscribe to the Federal's YouTube page for more news and updates.